Now I want to turn to Idaho, where prosecutors in the Doomsday couple murder case are asking for DNA testing on hair, a shovel, a pickaxe, and other evidence. Chad and Lori Daybell are charged with multiple counts of first-degree murder and conspiracy for the deaths of Lori's two children, JJ and Tylee, as well as Chad's ex-wife, Tammy. Joining us for more details on this motion is Court TV legal correspondent Chanley Painter. And I know, Chanley, you've been following this case very closely since the beginning. What exactly does the prosecution want here?
This is actually a renewed motion, Joy, for consumptive DNA testing, or DNA testing that would consume the sample that they were gleaning from the alleged crime scene here, where the bodies were buried of Tylee, Ryan, and JJ Vallow, found in Chad Daybell's backyard. Now, this motion is a second time the prosecution has attempted to consume the DNA sample, but it goes into more detail as to what items they specifically want to be tested. Now, this first motion was made in April 2021, right before Lori and Chad were indicted for murder, and Lori became not competent to stand trial, so her case was put on hold. So originally there was no decision made on this DNA testing. It was put off, and now the prosecution wants to renew this motion and try to convince the judge to allow them to consume these DNA samples. And here's essentially what this brief outlines for that testing. They want to test hairs on duct tape inside the body bag used to transport the remains of 7-year-old JJ Vallow. They want to test the ridge detail, or the fingerprints, on the adhesive side of the tape associated with JJ's body for touch and trace DNA. There was duct tape on JJ's body. Also, small dark spots on the handles of a shovel and a pickaxe recovered from a garage or a barn for human DNA. Remember, there's this red barn on Chad Daybell's property. So a shovel and a pickaxe found there. They want to test those dark spots, presumably blood, for DNA. They also want to swab areas of tape that were found with JJ Vallow's remains. Swabs from JJ Vallow's fingernails, his right hand fingernails obtained during his autopsy. They want to test those swabs for DNA here, and this DNA testing would consume those samples. Under precedent, defendants have the right to have independent testing of DNA samples, to have their own experts evaluate this, but there are circumstances in which judges can allow prosecutors to consume samples. So in the brief from the prosecution, it does say in part that the state has not yet performed that consumptive testing of any samples of DNA evidence or genetic material identified in what I just told you. However, the above samples cannot be effectively tested without being consumed. The defense in prior proceedings has informed the court of its objection to any consumptive testing. However, through the affidavit that they also attached with this motion, Joy, Ms. Nolan of the state crime lab there established that a valid scientific purpose for consumptive testing is there. So absent a showing from the defendant that the testing may destroy the material and exculpatory evidence under the Brady statute were being consumed in bad faith, the court should allow the consumptive testing of samples obtained to be potentially useful evidence. So in the past, the defense did object to this consumptive testing, and as of right now, this is a new filing, so there's no hearing yet set on this matter, but I'm sure the defense will be asking for one.
Yeah, and I guess that leads to the next question. What's the defense expected to argue here?
Well, the first time around, again, last April, both Lori and Chad's defense attorneys objected. They asked for a hearing. Here's what their motions at that time entailed, and of course they haven't yet filed their response to this renewed motion, but here's what they argued last time: no testing on remaining DNA until defense can obtain half of the samples for their own testing. They also wanted the prosecution to provide all the records on testing already performed and allow the defense DNA expert, their own experts, to be present and test this sample and provide all evidence related to DNA testing in this case. So, of course, they cite the due process clause of the Fifth Amendment, that the prosecution has a duty to preserve all material evidence and allow for that independent testing, and only with a scientific basis would they be allowed to do this. So we can expect this battle to go on and see if the prosecution is able to consume those items that are on possibly really incriminating evidence found on Chad Daybell's property.
Yeah, and you know, it's such a complex case, and you know, and it's been unfolding for quite a long time, Chanley. What do we expect next?
Well, we do expect a hearing, of course, to be taken up on this DNA matter. And as of right now, I'll keep checking the docket. The next hearing for both Chad and Lori is a pretrial conference hearing in November. That's the next hearing on the books currently, but there are pending motions from Lori Vallow's defense attorneys about the grand jury indictments against her. And of course, they'll probably have a hearing, of course, on this DNA testing. Their trial, their joint death penalty trial, is scheduled for January 2023, Joy.